Hi, this is Scott Shaw. This video is about a custody election of a child age 14 or older in the state of Georgia. The law has become more complicated and has changed since a recent appellate court decision. And so this video will analyze what powers a child age 14 actually have to make a child custody election in the state of Georgia. That's me. I bring this up because we are Georgia child custody attorneys, and we actually do know what we are talking about. And we're going to talk about the new decision by the appellate court and what it means for 14-year-olds and their power to make a custody election. So what does the statute actually say about the power of a 14-year-old child to make a custody election? Well, a child age 14 or older has the right to make a custody election. And in fact, the statute goes further. That right is actually presumptive unless it is shown not in the child's best interest. Whereas a child age 11 to 13 years old only has the right to make an election, but the election itself is not binding in the court. Simple, right? Well, not so fast, as I've mentioned a few times. The Court of Appeals of Georgia has just mucked things up a bit like the pigs in the mud there. And they pretty much read the word presumptive out of the statute. What we do know it means. One thing that has not changed is that if you want to modify a child custody order, you have to demonstrate a material change in circumstances that affects the welfare of the child. It can be a good change, it can be a bad change, but it has to be a change. Not changed by the new laws that the custody election of a 14-year-old is, in and of itself, a material change of circumstances. As a matter of law, if a 14-year-old decides he or she wants to live with the other parent, that is enough to get you into court for a custody modification, and this remains unchanged law. It's settled. Likewise, if a 11 or 13-year-old elects to live with another parent, that in and of itself is not considered a material change of circumstances, which means it's persuasive, but you have to come up with some other reason to modify custody as well. So this law is well settled and remains unchanged. So clear enough, right? Wait a minute. The problem starts with the language of the custody election statute. The custody election statute goes, children 14 years or older have the right to make a custody election, and their custody election is presumptive unless it is not in the best interest of the child. So what precisely does this mean? Last year, I successfully argued it means the child gets to elect the parent they want to live with unless that parent is proven to be unfit. Thus, once a child makes a custody election who's age 14 or older, it is presumptive unless the parent chosen is unfit. Thus, the word presumptive means something. It gives the child the right. It's not the parent the right to have the child elect them. It gives the child the right. And the trial court agreed with me on this, and this also fit prior Georgia precedent in third-party custody like grandparent custody and relative custody. It is also what the statute seems to say when read in context. So, yippee, victory for us, right? Well, in that particular case, maybe, but not so fast. The Georgia Court of Appeals disagreed with myself and with the trial court's interpretation of what this custody election statute means. In the case of Belknap versus Belknap, which I know very well from many years ago, the appellate court read out of the statute any meaning to the word or to the term presumptive. Instead, despite the 14-year-old making a custody election that's supposed to be presumptive, just ignore that, throw it out, and it comes down to just the best interest of the child. The 14-year-old's election is still a change of circumstances, so it gets you into court, but the custody election has no real power beyond that. And yet, shock. While saying they were reading the clear language of the statute, they actually read the clear language of the statute out of the statute. Where does that leave us? This decision, I predict, will probably be overturned at some point by the Georgia Supreme Court, which is the higher court above the Georgia Appellate Court. Once a case gets there, or further explained by the appellate court in a subsequent decision to make it make more sense. But until then, what it means is the custody election of a 14-year-old or older child gets you into court. Thereafter, you need to fight to win a custody trial based upon the Belknap decision. Also make sure you when you're in the case, you make a ground for appeal, because given how unsettled this law might be, you might actually win on that appeal as well. So you win the case in the best interest, but you set up the appellate record to win it on appeal if necessary. So that is the status of 14-year-old custody elections. This is all we do. We represent parents in divorce and child custody cases. And we know getting a fair shake in court, sometimes, most of the time, it takes a real fight. It is what we do. Feel free to contact us. Thank you.